We're going to discuss forum non-conveniens, which is a Latin term for inconvenient forum, and a forum refers to the chosen court for the dispute. However, this doctrine relates more to the appropriateness of the chosen forum than inconvenience. It serves three purposes. It ensures that correct courts hear disputes, it supports comity and harmony between nations, and it prevents plaintiffs from forum shopping. The modern approach to forum non-conveniens developed in the English case of Spiliata, where it was said that the defendant would be required to establish that there is a more appropriate forum for the dispute to be heard in. And to determine that, we look at the availability of witnesses, the party's place of business, and the law of the cause. Let's take an example. John downloads a copyrighted movie off of Free Movies Now based in Iceland. John lives in Texas, and Movies Express, the production company, is registered in London. Movies Express brings an action against Free Movies Now in the Federal Court of Australia. So then, our witnesses are located in the United States, Iceland, and England. Our parties, well, one's located in England, being Movies Express, and the other is in Iceland, being the website. And the law of the cause could be English law, Icelandic law, or potentially United States law. However, nothing points to the Federal Court of Australia having jurisdiction for this dispute. But, if it can be established that there is a forum non-conveniens, a plaintiff can resist the challenge by showing they'll be unable to rely on a legitimate judicial advantage, and this could generally be in the form of a longer limitation period, as some countries have rather strict limitation periods imposed. The Australian approach was developed in the Oceanic Sunline case, where a respondent lived in Queensland and had organised a holiday to Greece, and for his cruise ticket it stated that any action against a carrier was to be brought in Athens court. Whilst on the cruise, a shotgun exploded, injuring the respondent, who commenced proceedings in the Supreme Court of New South Wales. So the issue was whether Spiliata should be applied. Ultimately the test was rejected, but Justice Wilson and Toohey applied the test. Justice Brennan favoured a traditional approach, where Justices Dean and Gaudron took an intermediate position based on a clearly inappropriate forum, and this approach was explored further in the case of Voth. In this case, the plaintiff was a company incorporated in New South Wales, and the defendant was an accountant in Missouri. It was alleged that the defendant provided negligent advice to a subsidiary of the plaintiff in Kansas, and then the defendant was served out of the Supreme Court of New South Wales. So could proceedings be stayed? Well, the Australian court was held to be a clearly inappropriate forum, and the doctrine of forum non-conveniens was modified in Australia. Australian courts will only decline jurisdiction if proceedings are vexatious, oppressive, or an abusive process, and they will be vexatious and oppressive if the court is a clearly inappropriate forum. So what is a clearly inappropriate forum? Well, we go through the exact same factors in Spiliata and apply them the same way with the addition of the second limb of the test. But what's the difference then? Well, Spiliata tells us to look to a more appropriate forum, so why is somewhere else more appropriate? While Voth tells us to look inwards at why the court we are in is not appropriate. So in summary, the Voth test applies in Australia, and the relevant factors come from the case of Spiliata.